Hi, my name is Laura Genovich, and I'm a shareholder in the Municipal Practice Group here at Foster Swift. One of our specialties is working with municipalities who are dealing with controversial or high-profile issues, sometimes for the first time. It might be marijuana regulation, wind energy, mining, resettlement of refugees, or a host of other issues that draw a larger crowd to public meetings than the public body might be used to. Well, today we have 3 tips for dealing with these controversial issues and making sure that you stay within the bounds of the laws for municipalities. The first tip is to make sure you have a public comment policy in place. When your meetings haven't been as well attended in the past, you might treat public comment informally. But when you have a large crowd of maybe 100 people show up for your township board meeting, you want to make sure you have a policy in place for how long each person can speak. But it's important to make sure that that policy provides that everyone will have a chance to speak, because you can run into problems with the Open Meetings Act if you say, for example, that you can only have 15 minutes total of public comment, because that would leave some people without an opportunity to speak. So we draft these policies for clients and coach them on how to make sure they are complying with the Open Meetings Act, even when the room is much more full than they are used to. The second tip is to consider an alternative meeting location. Your township hall might not be big enough to fit everybody who wants to come to a public hearing on a particular issue. If you can anticipate this in advance, you may be able to reserve a school gymnasium or community center or other venue, and we can help you to make sure that proper notice of the alternative meeting location is provided. And that too can help you avoid any Open Meetings Act issues. And the third tip is a general tip to be very careful about the Open Meetings Act and the Freedom of Information Act when dealing with these high-profile issues. Of course, complying with the Open Meetings Act and FOIA should always be a priority for our municipal clients, but we take a special care to make sure that all the I's are dotted and the T's are crossed when we're dealing with these high-profile issues. For example, if you have a group email with a quorum of members of the public body and somebody hits reply all and deliberates on an issue that's before the public body, you could run into a problem with the Open Meetings Act. So one of our jobs is to work with the public body to avoid those things from happening. If we can help you with these kinds of issues or any other municipal law issues, please feel free to give us a call here at Foster Swift.